and he will take us through the new landscape for dispute resolution in the CIS. So thank you very much for joining us. The floor is yours. Cheers.
Ladies and gentlemen, my name is Matthew Parish. About slightly less than 2 years ago, I set up a law firm here in Geneva, headquartered here, called the Gentium Law Group. It's my pleasure to appear before you today as the managing partner. What do we do? We're dispute resolution lawyers. Now, you may think that's a service you're never going to want. And I assure you, you're absolutely wrong. One of the greatest mysteries, for I work in a much maligned profession, of course, lawyers, who like them, but one of the greatest mysteries in my profession is the following, and it comes out of people like yourselves. It comes out really of commodities traders in particular, who have a narrative which goes something like this. Oh, all the lawyers involved these days, isn't it ghastly? You know? In the old days, we did everything on a handshake, and we were all like a club, and we all knew each other, and the legal documents and the legal details weren't necessary. And if you didn't do a good deal, you got frozen out of the community, and therefore we didn't need lawyers and all this regulation and all this control. How did it get like this? Bar humbug. Now, I'll tell you that is nonsense. It's nonsense on stilts. And the reason I know it's nonsense is that the proportion of commercial litigation and arbitration which is initiated in relation to trading and shipping disputes is extraordinarily high. Something like 50% of all commercial disputes, full stop, under English law, which is the predominant commercial law used for international business transactions, are about trading and shipping. And even more are about other sorts of deals. Upstream deals, finance deals, related banking deals, and all the other sorts of disputes I also do. And about 50% of my practice, or even more, is just about trading and shipping deals and the various ancillary pieces to them. So in fact, commodities traders are some of the biggest users of dispute resolution services, and they always have been. And if you go to the English law reports, all the important cases have names of ships or have names of trading companies. The trading disputes and the shipping disputes have made some of the main precedents in English commercial law. The sorts of things that students read about in law school. They were all derived from your business and ultimately paid for by yourselves. And I've always wondered, why is this? What is it that makes commodities trading such a litigious business and continues to be so? And there's a line out of Shakespeare, Henry IV, Part 2. You know the famous line that says, the first thing we do, we kill all the lawyers. And there's a next sentence which is quoted less. Is it not this a lamentable thing, that the skin of an innocent lamb be made parchment? That parchments being scribbled over shall undo a man. Some say the bee stings, but I say 'tis the bee's wax. For I did but seal once to a thing, and I was never mine own man since. What is that quote about? It is about buyer's remorse. And it is about buyer's remorse in the case where people who are doing business are not engaged in point transactions. The people who don't need lawyers are the commodities traders who do the Turkish bazaar. You go into the bazaar, you have some cash, you see the commodity you want, you look at it, you argue a bit with each other, you swap the two together, and you walk out and there's no legal rights. You can't take your product back. It's a point transaction because it takes place at a single point and a single time. And as long as you're willing to do all your business like that, you never need lawyers. You look at the product, you make an assessment for yourself, you do the deal or not, you walk away, no law, no litigation. The point at which you need lawyers is, of course, the point at which you all start to make real money, which is that you don't want to do point transactions. You want to do transactions which are relatively sophisticated and complicated into the future, stretching over time. And the remorse of the signatory to the contract that Shakespeare identifies is an inevitable consequence for one person or another of having contracts which bind people into commitments in the future. Because what happens is that things change. And what looks like it was a fair split between the parties turns out to be less of a fair split. Or the margin or the profit looks like to be less. Because everything changes all the time. Firstly, if it didn't, there wouldn't be any money in commodities, would there? Because everything would be, competition would mean that absolutely everything is cut straight to the bone. So variety is important, because the winners are the people who can predict, and the losers are the people who can't. But precisely the variety, which is what drives the business of the healthy industry as it is also precisely what drives all the disputes. Because things change, and then somebody realises later on they've got a wrong deal. Or a third party comes along and steals something. In which case the question is, where does the loss lie? You've got banks, the insurers, the buyers, the sellers, the shippers, the owners, the charterers. You know the story. So that's what Louis lawyers are doing. And that's why, I'm afraid, we're so heavily infected into the business of commodities trading and of energy trading more generally. We're absolutely everywhere. And that's because the deals that are being done are often long-term, either in for commodities trading, it may be transactions over several months, or when it comes to some upstream project, it may be over a period of 20, 25 years for production sharing agreements, or for exploration rights, or something of this kind. And a huge number of things can change. And lawyers are part of the process of managing dispute resolution and managing problems when they arise in the course of relationships that change. So that, in essence, is what I do. Now, I've been asked today to talk about resolution of disputes in the CIS, post-sanctions, and I'm going to do that a little bit. But the real lesson, actually, is that the CIS is much like virtually everywhere else. Because the problem you've got, well, this is why we make the money in commodities, right? This is why there's money in oil. Because it's cheaper to get it out of the ground. The price at which you get it out of the ground in a low rule of law country is lower than the price at which you sell it in a high rule of law country, plus the logistical costs. That's where the profit is, right? Otherwise, nobody would do it. And indeed, markets will make it so this is always profitable, because those are the laws of supply and demand. So, the problem with the CIS, which is, as we discussed in our panel yesterday, one of the main sensors for energy production. The problem with the CIS is it's traditionally considered to be a relatively low rule of law environment. And people are trying to do things like take security over cargoes, something every trade finance officer knows all about, in an environment where there isn't much legal security. And an environment which is inevitably disputatious, because things are going to change and there is going to be a lot of litigation. Yet you don't have a domestic legal system which you can rely on. And then the question for the lawyers, both for the theoreticians and for the practitioners, is how do you extract what is basically a legally risky exercise, getting some oil out of the ground in Russia with lots of different people cooperating, for example, where if something goes wrong on the ground, access to a local legal judge may not be quite what you want. How do we extract our legal relationships out of a low rule of law environment and place them into a high rule of law environment? And that is very roughly what everybody who works in commodities has to do, who's dealing with emerging markets, as they're described. That's the basic challenge. So the CIS, the Commonwealth of Independent States, as you know, is more or less the countries of the former Soviet Union, with a few dropped off for various reasons. But it has all sorts of risks. The legal system and administrative system is underdeveloped. There is a terrible lack of clarity. There is bureaucracy, and politics can affect the bureaucracy. There is what is called resource nationalism, which is that the government will make decisions preferring its own interests over those of investors. So you think you've got an agreement or a contract, that piece of parchment sealed with the beeswax, right? You think you've got an agreement to do X, but somebody moves the goalposts afterwards. And the people who are best at moving the goalposts are governments. Right? Because what is law? It's just emanation of the state, right? I mean, law is worthless unless the government is ultimately going to enforce what lawyers and courts and judges and everybody else do. Business works in the shadow of the law, because if you break the law, then someone will ultimately come and use physical force to stop you from doing this, right? I mean, that's legal theory. Otherwise, legal documents you might as well not draft. So resource nationalism is a classic example of the state interfering in what you think is a contract signed with the beeswax later on to redistribute it in its own favour. And then you've got, of course, states don't just interfere in their own affairs. They like to interfere in other people's affairs too. Sanctions are a classic example of this, where one state decides to exercise a long-arm jurisdiction over the affairs of another state and regulate what you do in its country. Why do they do that? Well, foreign policy. Why not? Just because they can. States are powerful like that. The usual solution to resolving these problems is that some foreign law is applicable to any particular contract. And I'll say this to you now, no matter how many contracts you review or draft, no matter how much you think I'm fine or back office is fine doing that, the one clause in every contract you must consult my advice on, or a lawyer's advice on, is the choice of law clause and the choice of forum clause. Because those are technical and essential, and nobody thinks they're important, and it turns out that they're the most important clauses in every contract. Because the contract can mean and have a completely different effect depending on those clauses, and the way it's enforced, if at all, will be determined by those clauses. So if you get them wrong, you may have a worthless contract, or you may have a contract that means something different from what you thought. English law is generally used. What's the historical reason? The historical reason is that, very roughly, England was doing a lot of trading before many other countries, and it developed a legal system through its guilds and through the common law in London, going back to the 17th century. It developed commercial law, by which I mean basically the law of buying and selling things, or the law of putting things on vessels. The way those contractual relationships work, that was all developed earlier than anywhere else, and therefore to a more sophisticated extent. England has also been very good at publishing cases and reports, and its judges have been more than willing to do that. So what you'll find in English law is your standard charter party type clauses and contracts may have been the subject of judicial consideration. Ever wondered what a weather working day is? There's an English case law on that. That's not true in most jurisdictions. It says English courts and judiciary have a long-standing and ongoing reputation for prompt, efficient and fair dispute resolution. I'm not sure I would say it's prompt. No law is prompt. First time you've walked into a bad lawyer's office, they say, oh, we'll sort all this out very quickly. There's nothing quick about the law, as I'm sure you all know. But it doesn't necessarily matter. Delay is always going to be a bad thing. Because it's relative standards of delay. My experience is Swiss courts are often extremely slow, for those who've ever been involved in them. Many countries' courts are very slow, but if you can resolve a case within 2 or 3 years, that's quite good, because most likely it'll settle well before then. Whereas if everybody knows a case will take 10 years to resolve, then it probably won't settle until you get to year 8. People negotiate and settle cases in the shadow of the law. What judges and arbitrators actually say and do at the end of the day usually isn't very important. It's what they might say or do which is important. And in the meantime, you've got people negotiating behind the scenes. That's the way we lawyers work. I want to say something about arbitration. Arbitration is basically privatised courts. People talk about arbitration all the time. Most disputes in the commodities sector are resolved through arbitration. Is it a good thing? Well, it's like saying is private medicine a good thing? I mean, yes, of course, because the fact that it exists means it's meeting a market demand because people are not happy with the equivalent of public resources. If they were, then there wouldn't be a market in private medicine. So, yes, you're buying a superior product. But you're buying your way out of the state system, and you're saying, we're going to have our own private judges, and we're going to pay those judges by the hour, just like we do our lawyers, and we're going to call them arbitrators, and they're going to resolve the dispute for us, using the rules we want, hopefully in a more efficient and effective way, confidentially if that's what we want, and along the timescale we want. Now that's the theory. The practice is that arbitration is not always cheaper, but I still think that it is on balance. You know the people who really don't like arbitration, because there have been swings between court litigation and arbitration over the last few decades. The people who are really coming out now and not liking English arbitration are English judges. Why do you think that is? It's because they're now complaining that they've got no more case law. Because what do you like to do if you're a judge? You like to write decisions that get published and then get read by law students. Right? That's your main motivator. And you want to see the common law develop. And the problem with arbitration is that it's all private, and those decisions aren't written down, and then because jurisdictions have been competing in a race to the bottom to make sure the courts don't interfere with arbitrators' awards, therefore there's no effective appeal, as the arbitrators' law being made by arbitrators effectively isn't being made at all, because it's all being hidden away. And that's a debate that's currently going on. Right now, between England, Switzerland, different arbitral institutions, arbitration is so private that it's impeding the development of the law. And the argument from a client's point of view is this: I don't want to pay the extra amount of money it costs to create and develop the common law. I don't want to subsidise that. Okay? All I want is my own dispute resolved as quickly and simply as possible. I'm not interested in subsidising the grander system. Whereas judges in England say, no, you've got to subsidise the grander system, because the reason the system ever worked in the first place is because money was subsidising it and creating case law and creating judges who were writing decisions, and you've got to keep that going, Mr. Modern Client, just like all your predecessors did over the decades and centuries earlier. So that debate is now going on that's the main difference between litigation and arbitration. A person engaging in court litigation is to a certain extent subsidising a system which sees its goals beyond merely resolution of the dispute as hand. They may say it as maintaining the judiciary, maintaining the integrity of the legal system, maintaining the case law, whatever it may be. Debates about whether you can enforce court judgment and arbitration awards worldwide are very, very technical, generally of only interest to lawyers, but suffice it to say, if you find it difficult to enforce an arbitration award in Russia, you'll find it difficult to enforce court judgments in Russia as well. That's just life. These are some of the advantages of commercial arbitration set out. Again, an arbitration is easier because you can set the rules. I don't know whether any of you have seen court rules, but in virtually every country in the world, they're usually large, fat books. For some reason, most countries of the world, they're either green or white. I don't know why. But they're full of complicated rules, because judges have laid rules upon rules. Because, look at it like this. If a group of people come together in a voluntary association to write some rules, they're probably not going to want a lot, because they're not going to want to make things complicated. And that's what happens in arbitration. Or the rules of the STSA, I've got to read, but I'll bet you they're short and easy, right? Because it's essentially a voluntary group of people. Whereas if bureaucracies make rules, they tend to make them much longer. That's the main difference between litigation and arbitration. But these are the sorts of mechanisms that people are using to resolve disputes in England, in Geneva, in the various judicial arbitration centres worldwide, the related disputes right the other side of the world. And this is happening every single day, and this is what I do. Virtually none of the cases I do have anything to do with Switzerland at all, apart from perhaps the accidental location of one of the parties to the dispute in Switzerland. But the cases are not about Switzerland. They're about ships on voyages on the other side of the world. They're about accidents that have taken place on loading and unloading. They're about people having stolen cargoes in the middle of countries thousands of miles away. Some of the bodies used to resolve international disputes. You may have heard of some of these. The International Chamber of Commerce is in Paris. The London Court of International Arbitration is in London. Stockholm is an intriguing venue for dispute resolution. It was the only place in the Soviet period during the Cold War which the Soviet Union would allow Soviet companies to arbitrate disputes with. So it became an arbitration centre as a sort of neutral forum with, in disputes between Soviet companies and Western companies. It then had a dip, and now, in the current political environment, it is finding that has a substantial caseload increase more recently. There are also arbitration institutions in CIS countries themselves. You've got Russia, Ukraine and Belarus here. These are generally not used in the context of international transactions. They are not perceived as reliable. They are not perceived as lacking the requisite levels of corruption. The reality is that although there are arbitration institutions in many places in the world, the main centres of arbitration are, and I'm just taking them west to east, London, New York, London, Geneva, Dubai, Singapore, Hong Kong and Sydney. That is generally, Paris I forgot as well, that is generally where arbitration is done.